What's up, everybody? It's Make It Make Sense, and I'm starting to feel like I'm a fact-checking channel. Like the videos, the intro plays, because yes, some of the stuff in the Little Rod case is a no-go, and the judge literally did kind of like read the hell out of Tyrone Blackburn. So we got to talk about it. Like the videos, the intro plays, we got a lot to get into.
I was listening to Make It Make Sense. Shout out to Make It Make Sense. Thank you.
Make it make sense to me intellectually.
Make it make sense.
Make it make sense.
Big moves.
Surfer.
Make it make sense. Tell me how you squeeze it. Make it make sense. Tell me about the things that you see. Make it make sense. Tell me about the things of your dreams. Hey, let me work out all the things in between. Make it make sense. Tell me how you squeeze it. Make it make sense. Tell me about the things that you see. Make it make sense. Tell me about the things of your dreams. Hey, let me work out all the things in between. Make it make sense.
No, this is the party.
Oh, why? I just come back when everybody get here. Nah, stay. Nah, it's cool. I just come back later when everybody get here. I said stay! Oh, Diddy, all right, I'm here.
Party with me, Daddy.
I'll be the first one here, okay. Where everybody at?
It's just me and you in here today. Yeah. Now come dance for Brother Love.
I mean, ain't no music playing right now.
I said dance for Brother Love! Take that. Okay, guys. So, like I said, some were, but not all. And before we even get into the actual filing, when we started reading a lot of the Tyrone Blackburn lawsuits together, we had a good time in how he chose to write them. But I always said, all of the other attorneys that I talked to say, although they would watch the video and they would think, okay, he threw everything in the kitchen sink in it, they would not actually file their suits the same way. Tyrone Blackburn has a way of seemingly filing his lawsuits for us. Not necessarily what might be best for their client. And although he was not sanctioned, what we're about to read, the judge is literally like tapping his ass and saying you are close to getting in trouble. So I want to point out that Little Rod, as I understand it, was extremely nervous around the time of Diddy harassing him. You guys remember he was having private investigators call and talk to his daughter, who's a child. So I don't fault Little Rod for any of this. I do feel like Little Rod is a victim and he deserves whatever he can get out of this court case. But I don't think it's fair to him, if what the judge is saying about the attorney is true. But it says, this is from Paul Oakton, the district judge. Factual background: Rodney Jones brought this action against Sean Combs, asserting a variety of claims based on Combs' alleged history of sexual assault and human trafficking. Named alongside Combs are Combs' son Justin, the actor Cuba Gooding Jr., Combs' chief of staff Christina, his record label Love Records, his company Combs Global Enterprises, and an unidentified female described as Young Miami's cousin. She's been identified though, right? The second amended complaint asserts 17 causes of action, of which 14 remain. These include 2 federal claims, a RICO claim against Combs, Justin, Coram, Combs Global, Love Records, and a TVPA claim against Combs, Justin, Coram, and Combs Global, and various state law claims against Combs, Gooding, Jane Doe 1, and Love Records for breach of contract, sexual assault, premises liability, and infliction of emotional distress. The following facts are taken from Jones' complaint and are presumed true for purposes of this opinion. Jones' claims stem from his work between September 2022 and September 2023 as a producer on Combs' Love album. During this time, Jones lived with Mr. Combs for months, spending holidays, birthdays, and missing major family events. Jones resided at Mr. Combs' residence in Los Angeles, California, and Miami, spent several weeks on a yacht rented by Mr. Combs in the Virgin Islands and St. Bartholomew, and made several trips with Mr. Combs to New York City. Jones alleges that disturbing incidents began nearly immediately after he joined Combs' team. On approximately September 12, 2022, Jones alleges that he was present at Chalice Recording Studio in Los Angeles when Combs and Justin shot an unidentified man, and that Jones provided first aid services to the victim. Jones also alleges that he and other witnesses were pressured to hide the shooting from police and the public. Jones alleges that throughout his time with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching of his. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching of his anus by Mr. Combs, and that he was forced to work in Mr. Combs' bathroom as Mr. Combs walked around naked and showered. As you can tell, I'm going to read it as is. I'm not going to censor this. It is what it is. Combs allegedly used access to powerful individuals in the music industry, including producer Stephen Aaron Jordan, or Stevie J, to groom and entice Mr. Jones to engage in homosexual acts, including by sharing videos with Jones of who he claims was Stevie J anally penetrating another man. In addition, Combs promised to make sure that Mr. Jones wins Producer of the Year at the Grammys if he engaged in homosexual acts. Combs was allegedly aware of and attempted to downplay Combs' misconduct and worked with Mr. Combs to groom Jones into accepting a homosexual relationship. Jones alleges that other individuals in Combs' orbit committed sexual misconduct against him as well. For example, on Thanksgiving Day, Jones alleges that he was sexually assaulted by Jane Doe while he was staying in Combs' house in Miami. Jones also alleges that he was assaulted by Cuba Gooding Jr. when Combs left them alone together in a makeshift studio on his yacht. During his time working for Combs, Jones was transported from California to New York, Florida, St. Bartholomew. Am I saying that right? Is that St. Bart's? In the United States Virgin Islands. And while accompanying Combs to these various locations, Jones was allegedly coerced in participating in commercial sex acts against his will. Combs allegedly forced Jones to solicit sex workers and perform sex acts, and to bring prostitutes and sex workers back to Combs' home. On approximately February 2nd, 2023, Jones believes Mr. Combs drugged him and recalls waking up naked, dizzy, and confused in bed with two sex workers and Mr. Combs. Now, I did not know that he was in bed with Diddy. I remember this lawsuit pretty vividly, and I just remember him saying he was waking up with two sex workers. I didn't know he was in the same bed with the sex workers and Diddy. That's new to me. On approximately July 2nd, 2023, Jones alleges that he was present while Combs solicited sex workers, some of whom were underage, and forced them to drink liquor laced with narcotic drugs. When Jones attempted to leave, Combs allegedly forced him to stay, including taking Mr. Jones' car keys to prevent him from leaving. Jones alleges that Combs then forced him to drink the laced liquor, after which Jones began feeling lightheaded and recalls passing out and waking up at 4 a.m. the following morning, naked with the sex worker sleeping next to him. Jones alleges that Combs was intimately involved in Combs' misconduct and at times requested that Jones participate in transporting Combs' drugs and ordering sex workers on Combs' behalf. Jones states that Combs used his power and influence to intimidate and force Jones into performing these actions. This included promising Jones a Grammy, $250,000 to purchase all the instruments he wanted, ownership of Combs' $20 million property in Miami, and access to record label executives, as well as threatening Mr. Jones with physical harm. The threat took, and people say, oh, he promised him the $20 million lawsuit. We kind of went over that initially. I mean, the $20 million property. He was offering Justin Bieber his house and his cars when Justin was only like 14 or 15. So it's not unheard of for Diddy to offer people things that he knows he's not going to give them. He might give them something else, but it won't be no free money. In my opinion, unless you are protecting his secrets, then you might get some free money. But outside of that, he ain't giving that kind of stuff up. Blah, blah, blah. As well as threatening Mr. Jones with physical harms. The threats took various forms, including threatening to eat Mr. Jones' face, informing Jones that Combs was willing to kill his own mother so he wouldn't think twice about harming Jones, displaying his guns in front of Jones and bragging about getting away with shooting people, and telling Jones that Combs, head of security, had the power to make people and problems disappear. During the production of the Love album, Combs allegedly required his employees to consume alcohol and dismissed them if they refused, further stoking Jones' fear what could happen to him if he told Mr. Combs no. In addition to Jones' various claims of sexual misconduct, he also alleges that he was not compensated for his time living with Mr. Combs or for the songs Jones produced. Jones claims that this violated the terms under which he was recruited to work on the Love album, which included $20,000 upfront for each song he produced, 4 royalty points, credit as a producer, and for each instrument he played on the songs, and retention of publishing rights. Jones confronted Combs about this. Combs allegedly offered him $29,000 in total compensation, which Jones refused. Procedural background. Jones brought this action on February 26, 2024. This lawsuit broke the internet and filed the operative complaint on April 12, 2024. I can't remember if I broke this story or not, though. A year ago seems like 10 years ago. Y'all, do you realize we've been doing, like, this has been since November of 2023? This is crazy. But we will see this out to the end. Jones voluntarily dismissed his claims against certain defendants on May 14, 2024, and the court thereafter denied a request by those defendants to impose sanctions on Jones and his counsel. That's where we're getting the Tyrone Blackburn. Sean Combs, Combs Global Enterprises, and Love Records moved to dismiss the operative complaint on August 26, 2024, and filed a supporting memorandum of law. Quorum moved to join the motion on the same day. Jones opposed the motion on September 30, 2024, and the Combs defendants replied on October 18. Quorum also requested permission to join the Combs defendants' reply brief. Quorum did not file her own motion or memorandum of law. Legal standard. To survive a motion to dismiss under Federal Rule of Civil Procedure, a plaintiff must state enough facts to state a claim to relief that is plausible on its face. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. This means that a complaint is properly dismissed where the allegations in the complaint, however true, could not raise a claim of entitlement to relief. A company is also properly dismissed where the well-pleaded facts do not permit the court to interfere more than the mere possibility of misconduct. Okay, blah, 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 blah. Determining whether a complaint states a plausible claim is ultimately a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. Warning to counsel. Why are we so messy? Why are we so messy? Warning to counsel. Before addressing the substance of Jones' claim, the court finds it necessary to issue a warning to his counsel, Tyrone Blackburn. Previously, the court declined to impose sanctions on Blackburn related to the admittedly false claims he filed on behalf of Jones against Universal Music Group and associated defendants. Listen to this again. The court declined to impose sanctions on Blackburn related to the admittedly false claims he filed on behalf of Jones against Universal Music Group and associated defendants. While Blackburn may have acted incompetently at times, the court determined that there was insufficient evidence to conclude that he had engaged in a pattern of bad faith. Blackburn also has a pending referral to the Southern District's disciplinary committee for his repeated failure to investigate basic elements of his cases. In light of this, the court finds much of Blackburn's conduct regarding defendants' motion to dismiss to be unsettling. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and an inappropriate ad hominem attacks on opposing counsel. For example, in urging the court to consider a grand jury indictment of Combs on related criminal charges, Blackburn writes, as evidenced by U.S. Attorney Williams' press conference and the grand jury indictment, defendant Sean Combs and the RICO Combs enterprise are presumed guilty of being RICO criminal presumed guilty of being a RICO criminal organization. That any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. Then, rather focusing on the claims pleaded in the lawsuit, Blackburn writes that it is evident from the multiple civil lawsuits and the 14-page indictment the kind of sexually deviant monster Sean Combs is. Remember, guys, this is coming from the judge. I hope not. I absolutely believe the victims. But I've said this from the beginning. Everything is so salacious in this situation that you really do not have to do much. Like, you don't really have to add any sauce to it. You don't have to add the sauce to it. It's crazy on its own. You anytime you were filing a Diddy case, especially within those first 6-7 months, it was going to be a topic of conversation. It got bad when I think Busby took the case. I think that Tyrone Blackburn has his own way of doing things. He is a successful attorney, but some of those complaints read like a Tyler Perry play. Both the operative complaint and Blackburn's opposition brief are full of similar irrelevant insults, misstatements, and exaggerations. In response to defense counsel's understandable objections, Blackburn hurls schoolyard taunts at them, writing that it is clear that the defense counsel are obsessed with me. And I'll see, it can be funny, but it's not funny because he really does have victims that need him to be at the top of his game. So it's, I'm a layperson, so some of this stuff can be funny on its face, but it's not funny when you think about how serious this is and if his actions or inactions could potentially cause the victim to lose. It gets very serious very quickly. So I take back me laughing. Blackburn hurls schoolyard taunts at them, writing that it is clear that the defense counsel are obsessed with me. And although initially flattering, their obsession has become creepy. The court has inherent authority to sanction Blackburn should he act in bad faith, wantonly, or for oppressive reasons. While the court will not hold Blackburn's antics against Jones at this point, it warns Blackburn that further misconduct may lead to sanctions or to referral for discipline. Blackburn has a professional obligation both to the court and to his client to state the law accurately, to collaborate in a respectful and constructive manner with fellow lawyers, and to allow this litigation to proceed efficiently. The court will not hesitate to enforce this obligation moving forward. In terms of the RICO, Jones' first federal claim is for violations of RICO, which makes it unlawful to deploy the proceeds of racketeering activity in any enterprise, to participate in the conduct of such enterprise affairs through a pattern of racketeering activity. Defendants argue that Jones has not pleaded an injury to business or property caused by such violation and therefore lacks standing under the act. According to the defendant, the sole injury to the business or property alleged is the purported non-payment for services Jones claims he performed on the Love album. But Jones alleges no causal connection between this injury and any purported RICO predicate. Jones does not respond to this argument. A compensable injury to business or property encompasses specific pecuniary losses, blah, 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 but does not reach such personal injury suffered or reputational harm unaccompanied by a quantifiable and non-speculative loss of business opportunities. Such a compensable injury must also be caused by predicate acts sufficiently related to constitute a pattern for the essence of the violation of the commission of those acts in connection with the conduct of an enterprise. Blah, 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 blah. They're just stating case law. Both factual and proximate causation are required. The former is assessed under the familiar but for standard, while the latter requires that the RICO pattern or acts be a substantial factor in the sequence of responsible compensation, and that the injury is reasonably foreseeable. Blah, 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 blah. The Supreme Court has set out general principles surrounding this statute. one of which is that RICO is to be read broadly, not only because of Congress' self-consciously expansive language and overall approach, but also because of Congress' express admonition that RICO is to be liberally construed to effectuate its remedial purposes. Blah, blah, blah. Applying these principles to the operative complaint precludes most of Jones' alleged injuries from supporting RICO's standing, including his claims of trauma, mental health problems, emotional pain and suffering, and embarrassment and humiliation. Nor can Jones base standing on secondary economic consequences of these personal injuries, such as difficulty finding employment. Defendants are therefore correct that the only compensable injury that Jones pleads is defendant's non-payment for his work on the Love album. Defendants are also correct that their alleged refusal to honor the contract with Jones is not itself a RICO predicate act, even if the contract breach resulted from Jones' refusal to participate in Clome's alleged racketeering scheme. The question then is whether any of the other alleged RICO predicates or the pattern of racketeering activity as a whole caused by defendant's failure to pay Jones under the putative contract. The court cannot identify any such causal link. So there goes his RICO claims. Now, I talked to an attorney right before this, and most attorneys will wait until an amended complaint, or they will wait till discovery to really throw the kitchen sink. Blackburn just does it at the onset. So Rod does still have a case, but when you have the judge reprimanding the attorney in the decision and saying, we're not going to hold this against your client as of yet, it's not a good look. He still has claims. It's just he threw out everything and sued everybody. He casted a wide net, and the judge is coming back and saying, let's rethink some of these things. But Little Rod is not, he's I wouldn't even say he's down, but not out. I think that when you throw out so much, you kind of open yourself up to a judge saying, we're not going to take this to trial. We're not going to take this to trial. We're not going to take that to trial. But this is just for Camille.
To show y'all how we have fun and stay out of jail too, and make money.
I really do feel especially bad for Little Rod, because he was, in my opinion, based on his lawsuit, he was put in situations that he should not have had to be in. He was threatened. His kid was called. Not everybody is a super sexual person. Not everybody is sexually fluid, and your boss should not be the one to try to force you into any of these things. So I really do feel bad for Little Rod, and I hope that whatever issues the judge may have with Tyrone Blackburn, it does not hurt his case. Let's move on. Nor can Jones base standing on the notion that the defendants fraudulently induced him into the contract in the first place. Because RICO compensates only for injury to a business or property, a victim who is induced to part with his property by the misrepresentations of a fraudster is generally not entitled to benefit of the bargain damages, meaning recovery of what the fraudster promised as opposed to the property the victim lost. So I guess that specifically is speaking to him offering him a $20 million house. You never had it. He didn't give it. We can't sue you for that and claim it to be RICO. Jones also fails to plead any facts from which the court could infer that the defendants never intended to perform under the contract in the first place. Defendants sought to acquire wire transfers and cash payments and to utilize their talents and labor to produce music and other tangible goods and services without full compensation. And Jones identifies no specific examples of fraud occurring after the formation of his contract that reduced the value of the contract or caused defendants' failure to pay. While Jones repeats the word fraud throughout the operative complaint, he appears to often do so as a synonym for illegal and does not identify any specific misrepresentations related to the contract. In sum, whether or not Jones has adequately alleged the existence of a RICO enterprise, he has not tied the activities of the enterprise to the defendant's breach of contract or any other business property harm incurred by Jones. It also bears reiterating that Jones fails to address any of these arguments in his opposition brief, and while the court prefers to decide issues on the merits, it should not be necessary to root around a 402-paragraph complaint to contrive novel arguments on Jones' behalf. That is an intellectual read if I have ever heard one. Let's go back. It should not be necessary to root around a 402-paragraph complaint to contrive novel arguments on Jones' behalf. That's actually a read to Tyrone, since Tyrone wrote it. Well, I don't think he's a nobody producer. I do think that Tyrone has credits. I'm sorry, Lil Rod has credits. And at the time that he offered Justin Bieber a house, Justin Bieber didn't have an album. He was just somebody who wanted to work with Diddy, wanted to work with Usher. He was not a superstar. So he offered him, I think it was like a Lambo, and he offered him his house. So he's done it before. Yeah, they really aren't holding back on Tyrone. The court may and generally will deem a claim abandoned when a plaintiff fails to respond to a defendant's arguments that the claim should be dismissed. Again, that would fall on Tyrone. Combs. Jones next asserts TVPA claims against Combs, Quorum, and Combs Global. The TVPA makes it unlawful to recruit, entice, harbor, transport, provide, obtain, maintain, patronize, or solicit by any means a person, knowing or in reckless disregard of the fact that means of force, threats of force, fraud, coercion, or any combination of such means will be used to cause the person to engage in a commercial sex act. The statute does not define terms like entice or recruit, so courts have given those terms their ordinary meaning, holding that they cover conduct ranging from attacking a victim by offering something that arouses hope or desire to somehow securing the services of a victim. The term coercion is defined as threats of a serious harm to a physical restraint against any person. Any scheme, plan, or pattern intended to cause a person to believe that failure to perform an act would result in serious harm or to physical restraint. I don't know, like threatening to eat somebody's face. Diddy was probably threatening to eat a lot of shit. I wouldn't be surprised if he was threatening to eat him. Who knows? Like, he couldn't put everything in the complaint. I have a feeling that this lawsuit, or what is remaining of Little Rod's complaint, will make it to trial. And Little Rod will have his day to actually say specifically what this man did to him under no certain terms and be as bold as he can be. And I'm pretty sure what we read was just the tip of the iceberg. People don't, not everybody, we get a lot of this stuff, but I have everybody who watches me. And sometimes people really don't put themselves in that person's situation. You have somebody who could end your career. They're threatening you. We've seen this man end other people's careers. He's allegedly enticing you to move in sexual ways that you are not comfortable with men and women. And your career is on the line. You got child support that needs to get paid. You're spending a year with this man. You're seeing a lot. Everybody don't want to be around drug culture. Everybody is not okay seeing somebody sniff some coke. But now you have somebody who's constantly telling you, it's okay, I want you to do it. It's okay, I want you to do it. If you don't do it, your career is going to get hurt. Did you not see what I did to this person? If they can prove that shooting happened at Chalice Records, that opens a whole nother can of worms. I'm a little bit... I've been looking through the Diddy documents just because I'm not reporting on it. does not mean that I'm not actually looking through the documents. They have been doing a lot of shit sealed, and pseudonyms are being used. So I'm wondering if Little Rod has some additional proof. Well, I don't know, y'all, because I don't think that was included in the indictment, and they have not actually put out the list of names. They haven't done a lot of shit with this Diddy case that I've been waiting for them to do. If Little Rod had additional proof that that shooting happened, I would have assumed that that would have ended up listed in his indictment by the feds. I don't know. Momo, I've never blocked anybody from Cash App, but I appreciate you even offering to send one. I didn't know that my Cash App was scrolling. I was supposed to be having my allegedly banner. They are not putting out, like, they have a list of everything that needs to be filed, but things are being filed under seal. So I told you guys I'm gonna keep you posted though. Tough says, I think Little Rod hurt his own career with his lawsuit. Nobody will trust him ever to work with them. If being quiet means you have to do illicit drugs and engage in sex with prostitutes or sex workers, engage with sex workers and allegedly let Cuba Gooden Jr. touch your booty hole. I mean, he's clearly not into that. So, I mean, I don't think that he needed to stay silent. Just my opinion. If it hurts his career, that is horrible. It shouldn't, but I don't think he needs to stay silent. DB says, my only issue with Rod is he didn't see it as a problem until he didn't get paid. Maybe he saw it as a problem, but he was nervous. He was nervous that he wasn't going to have a career after it if he said something. And he also wanted to get paid. He'd been with the man for like a year. But, you know, I've heard that argument a lot. People felt like he didn't come forward until the money was an issue. The term commercial sex act means any sex act on an account which anything of value is given or received by a person. Let's see. Given the TVPA's breadth, Jones has adequately pleaded violations as to Combs. On numerous occasions, Combs allegedly recruited or enticed Jones to solicit and perform sex acts with commercial sex workers, as well as transported Jones across state and international borders in order to do so. Combs allegedly secured Jones' compliance with his request both of promising economic benefits that never materialized and by threatening Jones with physical restraint and harm. Because the operative complaint is lengthy and includes multiple examples of conduct adequate to ground a TVPA claim, the court here lists only a representative sample. Having traveled from his home in New York to Combs' home in California, he was allegedly asked by Combs to solicit female sex workers on Combs' behalf, including multiple individuals under the age of 18. When Jones expressed his discomfort with the situation and attempted to leave, Combs forced him to stay. We don't really need to get into that. Recalls passing out and waking up in bed with a sex worker. Jones has thus alleged recruitment to participate in commercial sex acts, along with physical restraint and a threat of force resulting from Combs seizing Jones' keys. Jones alleges that a similar episode occurred at Jones' home in Miami, when Combs drugged Jones and woke up naked, dizzy, and confused in bed with two sex workers and Mr. Combs. In addition to drugging and physically restraining Jones, Combs also allegedly used verbal threats of force and fraudulent promises to induce Jones to solicit and have sex with commercial sex workers. Finally, Jones adequately alleges that direct sexual assaults committed by Combs himself were commercial for purposes of TVPA. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching. Defendants make two arguments. First, defendants argue that Combs' threats and promises were so outlandish that they failed to meet the general requirement that the pleadings be plausible. Now, why Not I'm over here trying to try the case and I'm nobody's attorney. It's not outlandish. All they have to do is find the video with Justin Bieber where the man actually says, I'm going to give you this house and this car. He said it. I mean, I believe so. Coco says, didn't the girl from the yacht named Little Rod as a witness in her lawsuit? I believe so. I have not seen anything about that lawsuit. No, but I'll have to look it up and see what they're doing. I can tell you that Diddy has tried to dismiss most of these lawsuits. So now when you're going through them, you'll see a lot of dismissals that the judge is not paying attention to, I would say. Let's see. The court disagrees. It's not what Combs said that supports an inference of fraud. The context and history of Combs and Jones' professional relationship imports a degree of legitimacy, of materiality, or the statements. Combs is not only a successful artist and executive with extensive ties to the industry, but has a track record of winning precisely the awards that he's promised to Jones. Combs also has a long history of public allegations of violence, specific instances of which Jones witnessed firsthand. Given this context, it was not unreasonable as a matter of law to take Combs' promises and threats at face value. Thank God. What the hell is this? Moore versus Fox. Granting a motion to dismiss where the plaintiff claimed that she had been detained by the British monarchy at the Disney Yacht Club and forced to curtsy in the shower for 6 hours with the brain hijacking experiment. They're using this as, case law, but I just thought that was weird. Now I'm going to look that case up and see if she won. Being forced to curtsy in the shower for 6 hours? Okay. I don't put anything past the monarchy, though. Second, defendants argue that Jones fails to provide dates for some of Combs' threats and promises, and that Jones fails to link those threats and promises to specific sex acts. Defendants therefore argue that because no specific threat is casually linked to any sex act, Jones fails to establish TVPA. Let's see. Defendants are correct that Jones does not connect most of Combs' verbal threats to specific sex acts on specific dates. However, while a casual relationship is required, Jones' allegations suffice to plead one here. As in the Weinstein cases, the complaint must be read as a whole, not deconstructed and parsed sentence by sentence. Here, Jones provides a bounded time frame within which Combs' conduct occurred, namely the year that Jones spent living and traveling with Combs. Jones also alleges that throughout that year, he was the victim of unwanted sexual advances from Combs, along with ongoing campaign to groom Jones into accepting such advances. Let's see. Taken together and with all inferences drawn in Jones' favor, these allegations support an overall inference that Combs used a combination of threats and promises to secure compliance with his request, and that those requests included participation in numerous commercial sex acts. Federal pleading standards do not require more precision at this stage in the litigation. Thank God. Quorum. Now, y'all know Quorum just came out basically saying she ain't do shit. She ain't seen shit. She ain't shit. In my According to Jones, Quorum was Combs' chief of staff and was aware of Combs' sexual misconduct, including his unwanted groping and touching of Jones. Jones also alleges that he expressed his discomfort with Combs' behavior to Quorum and that Quorum refused to intervene, justifying Combs' conduct by saying that Sean will be Sean, and that it was just Combs' way of showing that he likes you. Okay. Quorum also allegedly requested that Jones order sex workers for Combs on at least one occasion. Defendants do not advance any independent basis on which to dismiss Jones' claims as to Quorum. It is reasonable inference that Quorum violated TVPA section by recruiting and enticing Jones to engage in commercial sex acts. Quorum may also be liable under Section 1.5 as one who benefited from Combs' venture, notwithstanding her awareness of participation in the venture's TVPA violations. but the court need not evaluate the secondary basis. Blah, blah, blah. Combs Global. We don't really need to get into that one. In addition to his federal claims, Jones asserts a variety of state law tort claims based on incidents of sexual misconduct that allegedly occurred while he was living and traveling with Combs. Although defendant's misconduct allegedly occurred in at least 3 states and 1 foreign jurisdiction, no party addresses choice of law in their briefs. Applying New York choice of law rules, the court determines for now that the relevant law for each of Jones' tort claims is the law of the state where the tort occurred. Sexual assault. Jones asserts a claim for sexual assault, which the court construes as a claim for assault and battery based on sexual contact. Combs' only argument against this claim is that Jones fails to allege sufficient factual detail, which both provides insufficient notice of the claim and renders plaintiff's claim implausible on its face. So you're not saying you didn't do it. You're saying that he didn't give you enough detail. I feel like it was pretty detailed. Now, he might need to say what he remembers happened when he woke up in the bed with the 2 sex workers and Diddy. And if it's not consensual, sounds like a good enough claim to me. While Jones does allege in general terms that Combs continuously touched and groped him throughout their time living and working together, Jones also alleges specific instances of unwanted sexual contact. This includes Combs drugging and sleeping with Jones at Combs' Miami home on February 2nd, 2023. Such allegations, at least some of which include specific dates and descriptions of sex acts, are sufficient to provide defendants with adequate notice. Again, I didn't even remember that he woke up in bed with Diddy. I just remember him waking up in bed with 2 sex workers, but he definitely did not give too many details about what might have or did not happen. Granted, he did say he was drugged, but I'm pretty sure that's going to have to come out at trial if this makes it. Let me see. Blah, blah, blah. Declining to dismiss a retaliation claim that failed to include specific dates or complaints of sexual harassment, but did plead that the plaintiff made ongoing complaints. He made them to Christina Quorum. Jones' allegations are also sufficient to state a plausible claim under at least the Florida law, which imposes civil liability for the threat of offensive sexual contact or the intentional infliction of such contact. Emotional distress. Jones asserts for negligent and intentional infliction of emotional distress against Combs based on the same conduct underlying his sexual assault claim. Jones fails, however, to adequately plead a required element of those torts, severe emotional distress. Regardless of which substantive state law governs Jones' claims, that element is required and must be pleaded with specificity. I feel like a lot of the emotional distress claims get thrown out. So that one I'm not surprised. Here, Jones merely recites the elements of the tort throughout the operative complaint without providing further detail as to the nature and extent of the emotional suffering he has experienced due to Combs' actions. I mean, do you have a therapist who's willing to testify or send something in saying that you have been, severely emotionally suffering? We don't want to do premises liability. Okay. Regarding Cuba Gooding Jr., the situation is similar. Jones alleges that Gooding's actions should have been foreseeable to Combs, as Gooding pleaded guilty to a misdemeanor charge based on sexual misconduct in 2022, among other publicly reported instances of similar misconduct. More importantly, however, Jones alleges that Combs intentionally left him and Gooding alone in a makeshift studio on Combs' yacht after suggesting that Gooding get to know Mr. Jones better, along with Jones' allegations that Combs was grooming him by frequently suggesting that Jones engage in homosexual acts. This supports the plausible inference that Combs foresaw and enabled Gooding's alleged assault of Combs. Combs responds that Gooding only had been accused of assaulting women, not men, making his assault of Jones unforeseeable. But it is not implausible as a matter of law to think that someone who has assaulted members of one sex in the past is more likely to assault members of the other sex in the future. Combs also argues that because he chartered the yacht on which the assault occurred and was not the yacht's owner, he cannot bear premises liability. Blah, 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 blah. Breach of contract. Finally, Jones asserts breach of contract claims against Combs and Love Records for failure to compensate him for his work on the Love album. In a contract case, New York courts will normally apply the law of the jurisdiction having the greatest interest in the litigation as measured by that jurisdiction's contacts with the litigation. However, as with tort claims, the first step in any choice of law analysis for a contract claim is to determine whether there is an actual conflict. Let's get to the good stuff. In New York law, an oral agreement that is void under the statute of frauds may not be served to save an otherwise enforceable agreement. Jones fails to respond to this argument other than by arguing that all of the songs composed by Mr. Jones were completed in less than a year. This is irrelevant as it is defendant's portion of the contract that could not be completed within a year, not Jones' portion. Because the oral argument is subject to the statute of frauds, Jones' contract claims are dismissed. Now that sucks. I just don't know how it seems like Diddy keeps getting away with stuff. I just don't see how he can. How do you have somebody? This man is on your actual album. He is credited on your actual album for all of these songs. After he comes forward to you and says, I actually want payment, you then tell him you're only going to give him $29,000 for a year's worth of work. Allegedly, you gave Carisha more than that for just play money. Like Carisha's alleged, what would we call it? I don't want to say salary because I like Carisha. Well, allowance. Carisha's alleged allowance was in the hundreds of thousands of dollars. And you don't want to pay this man who you allegedly tried to groom and play with his booty? I don't know. I definitely don't like that. Other defendants. On September 9, 2024, Jones filed a letter with the court requesting an extension of time to serve defendants Justin and Gooding. The court granted the request and directed Jones to serve those defendants by November 8th. Jones has not since notified the court that the service has been completed. I heard Cuba Gooding Jr. is avoiding getting served. Accordingly, Jones is directed to file a letter with the court explaining the status of the service as to Justin and Gooding within 2 weeks of the date of this opinion. Should Jones fail to do so, the claims against those defendants may be dismissed for insufficient service or failure to prosecute. If you got enough money, you can generally run away from service. Well, technically, I feel like if we know that Diddy's children are showing up to the courthouse, then why don't you guys just have somebody waiting out there to serve Justin where there's a million cameras? I would probably have the service people waiting out there at the courtroom. If you can't just normally find Justin, I'm sure Justin is taking bookings and stuff like that to do club appearances. That I don't understand. People travel across the globe to serve somebody. Jones has also not yet served Jane Doe 1, but has provided no explanation for his failure to do so. The court therefore dismisses Jones' claims against Jane Doe 1, which would be Carisha's cousin. Conclusion. For the foregoing reasons, the Combs defendant's motion to dismiss is granted in part and denied in part. The motion is granted as to Jones' RICO claims, negligent and intentional infliction of emotional distress claims, and contract claims. The motion is also granted to Jones' TVPA claims against Combs Global. The motion is otherwise denied. Jones shall file a letter within 2 weeks of the entry of this opinion explaining the status of service to Justin Combs and Cuba Gooding Jr. Jones' claims are dismissed as to John and Jane Doe 1 through 10 and ABC corporations. Defendants who have all been served shall file an answer to the surviving claims within 14 days. I still feel bad. Yeah, but if they haven't been served, you wait till he is there. They showed up to Chance's graduation. They showed up to the twins' graduation. Like, the Diddy Kid stuff is pretty public. You can figure that out. Justin was throwing parties and renting houses up until what, like 4 or 5 months ago when he couldn't do it anymore. Christian is all over the place. Just find out where his girlfriend's gonna be. That's where he'll be. Like, they just got a house. Like, I feel like you could serve these people. Does it cost money? Now that might be the problem. Tyrone, I'm sure took these cases not getting any payment until the case is won. So I guess now it would be on Tyrone to pay for the service, and then he would just get, he would recoup those funds in the lawsuit. So maybe that's it. Maybe it's expensive and they can't do it, but I believe Lil Rod. Now, some of the stuff was a little crazy, but I definitely believe Lil Rod was a victim. I believe that sometimes rich people in this country get away with shit that the rest of us couldn't, and Diddy definitely falls into that category. And I hope that they take him to the cleaners for whatever he has left. Anyway, the cases have been tried in public opinion. We know probably the smallest of information, but we don't matter. It's not about Diddy's activities. To them, it's about the money. I agree. I hope justice is served. I really do. And I'm really, really considering, going out there for the trial. I don't know. Maybe I will, maybe I don't. We'll see. Yeah, definitely hit the button on your way out. Oh, okay. So I found something else. It'll probably be a short video tomorrow, but it's about Oprah. So I'm looking into that now. Expect maybe like a short video tomorrow, but maybe some of Oprah's skeletons are going to be coming out. Just saying. I was surprised. So maybe tomorrow morning I'll put out the video that involves Oprah. So anyway, why are we like this? Y'all have a good day. I will see you tomorrow. Unless something else pops off, then I'll come back live. But I know the YouTube streets are on fire, and I have no comment. I know the YouTube streets are on fire. Y'all can stop DMing me these videos. I'm not getting in this one. So I will see you later. Bye, y'all.